So the first speaker will be Mr. Peter Wang from, he's a Deputy Law Officer from the International Law Division, Department of Justice, Hong Kong SAR government. And he's going to give us an authoritative introduction to this proposed bill and the consultation paper. So Peter.
Thank you. So thank you. Good afternoon, everyone, and thank you, Professor Liu, for the kind introduction. I'm going to use a PowerPoint, so let me just click it. And yes. Yes. So I'm going to talk about the government's proposal for the application of the CISG to the Hong Kong SAR. Starting with this broad topic, I think I'd like to thank the Center for Chinese and Comparative Law of City University for the arrangement. I want to make sure that you can move on. Perhaps I'll press 2. Let me see if it works fine. While my colleague is trying to sort out the technicalities, perhaps I'll dash on because of the time limit. And as this year is the 2020, or equivalent to the 40th anniversary of the adoption of the CISG text, we are very pleased to be able to celebrate it and also to launch the consultation in March earlier this year. As we mentioned earlier, the CISG is in fact an international commercial law treaty laying down uniform rules for the contract formation and substantive rights and obligations in relation to international affairs. But its purpose is to provide a modern, uniform, and fair regime, and thereby ensuring certainty in commercial exchanges and decreasing transaction costs. And in particular, the convention applies directly to contracts or sales of goods between parties whose place of businesses are in different contracting states in accordance with Article 118 of the convention. But of course, this is subject to the right to contract out, to opt out in whole or in part of convention under Article 6 of the convention. And as at today, there are 93 contracting states from diverse legal traditions and different levels of economic development. And they represent about 2/3 of the global economy. So in this regard, it is worth noting that while China, mainland China, is a contracting state to the CISG, it doesn't apply to Hong Kong. And against this background, in March, as I mentioned earlier, we launched a public consultation to end in September 2020. So today's seminar is really very timely, and we hope to seek as many views as possible to address quite a number of issues. And in the consultation paper, we include a number of issues, including the salient features of the CISG, the interplay between the CISG and relevant laws, and also the economic and legal policy, which we have taken into account in putting forward the proposal. And lastly, the implementation arrangement, including a draft bill. But the most important point, of course, is the basic question. Should the CISG be applicable to Hong Kong? I'm pleased to say that so far we've received a number of submissions from various organizations, including the bar associations, legal academics, sitting among us included, and from both local and overseas institutions. And the general approach is really to endorse the proposed application of the convention to Hong Kong. So I think probably what we're going to hear in the coming 3 hours is really about how we can do it better. We've put forward initial proposals, but the important thing is to make sure that we can fine-tune the proposals in such a way as to achieve the best results. So turning to the legal policy considerations, I want to mention briefly about the some economics. As Hong Kong is a major trader in the world, and in 2018, Hong Kong is ranked 8th in the world merchandise trade, including both exports and imports. And among the top 10 merchandise traders in 2018, only Hong Kong and UK are not CISG jurisdictions. So this is interesting in a way, but it has to do with the historical development. And I look forward to Professor Bridge to talk about the UK situation. But looking at Hong Kong, when we consider the top 20 trading partners in 2018, 12 of them, in fact, accounting for 77% of Hong Kong's total trade, are CISG jurisdictions or contracting states. And among them, mainland China has the first ranking, with over 50% of Hong Kong's total trade attributable to it. And these statistics, I think, indicate that more than half of Hong Kong's top trading partners are CISG contracting states, and therefore, by proposing to join the CISG or to apply to Hong Kong, we believe that it would enhance the potential in terms of trade and would facilitate trading arrangement between Hong Kong traders and other businesses. Let me then turn to the legal policy considerations. There are several. And firstly, we consider that applying the CISG to Hong Kong would bring benefits by enhancing Hong Kong legal professionals' competence in advising on cross-boundary sales transactions and in handling and resolving CISG disputes by means of arbitration and litigation, for example. This would help to consolidate Hong Kong's status as a leading center for dispute resolution and legal service in the Asia-Pacific region. And secondly, we look at the specific features of CISG itself. There have been a lot of discussions, competing considerations, but from our perspective, we view the CISG as a collaborative work and effort of the common law and civil law jurisdiction primarily, and embraces a number of important policies, including the pro-contract policies and also the principle of party autonomy. In relation to pro-contract, it's underpinned by a wide range of remedies in the CISG itself. We cite a number of examples in this PowerPoint, including, for example, Article 46 in relation to the right of a buyer to request repair of the goods and delivery of substitute goods in case of fundamental breach. There are other provisions as well mentioned this. And to a common law professional, I think this is really impressive. The right to cure defective performance is quite a unique feature. To fix additional time for performance, the reduction of price under Article 50, and other more standard perhaps remedies like right to claim damages and avoidance of contract. There are variants and differences between common law and the CISG, but on the whole, we do not see any fundamental incompatibility with the adoption of such a new scheme. Another important feature, of course, is party autonomy, or in our context, freedom of contract, because Article 6, in fact, allows contractual parties to either completely exclude the application of the convention or to vary its effect to suit their particular needs. And this flexibility, we believe, would allow businesses to use the CISG as designed or as tailored. And even for those who consider that the application of, for example, Hong Kong law would be more favorable to them, exclude the application of the CISG completely. Taking into account the above, in particular, the contract policy, the wide range of remedies, and also the principle of party autonomy, we consider that the application of the CISG to Hong Kong can actually enhance our legal infrastructure by providing for a set of neutral uniform rules specifically designed for cross-boundary sales transactions, and also as an additional choice of law options for our business with prevailing effect over local sales law. And perhaps I should add that in the context of the Belt and Road policies or Belt and Road initiatives promoted by the central government amongst the international community, is also in line with the Hong Kong government's policy to promote a rule-based trading system. And we believe that the adoption of this convention would actually reinforces the role of Hong Kong in providing professional services to Belt and Road countries, and also in particular by virtue of its status as the leading center for legal and dispute resolution services. It would of course be a remiss of me if I do not talk about the cost of the proposal. And here, I like to highlight this.
Okay. So I want you to think about you mentioned that look, you could think about finance, think about journey.
Apart from that, it will be a learning curve for Hong Kong, of course.
I'm quite confident I have
also for the legal profession.
But
I
want to worry.
There are other more specific issues like transaction costs.
Just on data center, I want to help me think.
For transaction costs, it might involve the need to get familiarized with the CISG and also to build a sense of contract. There may also be advisory or litigation costs, like working out different legal issues, including the interface between the old law and the new.
When we chase for more of these agreements to review and
introduced by the CISG, which may be foreign to the current
or be familiar with sector.
One example is about the concept of interpretation in Article 8. When ascertaining the intent of a party or understanding a reasoned person for the purpose of Article 8(1) and 2, the court must consider all relevant circumstances. And these, we notice, is different from our common law approach, which rely on the parallel evidence rule, which and therefore would require a bit of learning for everyone. Having said above, they may be considered largely short-term or one-off costs, similar in nature, inherent to other change of the law or law reform. As CISG practice and domestic case law mature, such costs may gradually be ameliorated. It appears from the above considerations and the application of the CISG to Hong Kong could bring significant benefit to Hong Kong, which would far outweigh its potential costs. While there is a learning curve to climb, we are confident that the legal and business sectors in Hong Kong, renowned for their versatility, will gradually get familiar with the convention and put it to good use, using the many publicly available and accessible informative resources, including commentaries and cases, notably the UN Cloud database. Let me then turn to the implementation proposal itself. There are two levels, of course. One is about the treaty law and the other is about domestic law. And subject to the result of consultation, and if it's decided that CISG should be applied to Hong Kong, the next question we need to look at is how to work out the details. At the treaty law level, because under Article 91, accession to convention is limited to states, Hong Kong being part of China as a special administrative region, we will not be able to accede to the convention independently. And therefore, in terms of way forward, if the decision to apply the convention to Hong Kong, we will need the assistance of the central government pursuant to Article 153 of the Basic Law, so that it could then be applied to Hong Kong at the treaty law level. At the domestic law level, as proposed by way of an initial proposal in our consultation paper, we suggest that there be standalone ordinance to implement the convention. And this new ordinance would reflect any declaration and reservation to be entered into Hong Kong, in relation to Hong Kong. And thirdly, the new ordinance should contain provisions with the effect that the CISG rule would prevail to the extent of inconsistencies. This we have taken into account the Australian and the some other common law jurisdictions approach. But of course, we've recently received submissions or suggestions, and we will look further into it in terms of how we should draft or refine the bill itself. The important point is that we need to guard against a homeward trend, which is something which we would be aware of, because Hong Kong is really renowned for its role as international legal service center. The judiciary itself is very familiar with the approach in terms of taking into account international jurisprudence. So the important thing is to give full effect to the autonomous meaning of the convention itself. So overall, incorporating the CISG by way of a separate ordinance, we can see there are various advantages, like drawing a clear distinction between the application of the CISG as opposed to the application of local law, like the Sales of Goods Ordinance. We can also make it clear that where the CISG applies, it will have a prevailing effect over Hong Kong laws. At this point, I'd like to deal briefly with two implementation issues, which I'm sure the speakers today might look into in greater detail. The first one concerns the Article 95 reservation. Our proposal in the consultation paper initially is to follow the mainland Chinese approach in terms of putting forward a reservation in relation to Article 11B. As we know, Article 11B deals with the application of the convention in cases where the rules of private international law of the forum lead to the application of the law of a contracting state. However, we consider that there may be a risk of confusion to the parties concerned, contracting parties concerned, and in particular, in the context of an arrangement between or a contracting agreement between parties in the mainland and Hong Kong. If we apply the reservation, there might be confusions in terms of smooth implementation. And therefore, I'd like to look further into the second implementation issue. It's about mainland China-Hong Kong transactions. As CISG is a treaty, it doesn't apply as between two jurisdictions within one country, the mainland and the Hong Kong SAR. We have considered that in order to take the benefit of the CISG, we think that for transactions between businesses in mainland China and businesses in Hong Kong, there will be advantages at this stage to do unilaterally to provide that to new ordinance. In the new ordinance, apply the substance of the CISG rules to such transactions. In due course, we may like to explore further whether there would be feasibility in having a bilateral arrangement with the mainland side, like what we have in relation to the reciprocal enforcement of arbitral awards modeled on the New York Convention. Time constraint doesn't allow me to go into great details on these issues, but I wish to include that in the light of the economic, trade, and legal policy considerations we briefly mentioned above, my department believes that the benefits of the proposal to extend the convention to the Hong Kong SAR would bring more benefits to us, and it would far outweigh the initial cost, including the learning curve that we need to climb by the legal and business communities. As for the next step, we would end our consultation in September 30th, and we will look carefully at the responses and submissions received from the consultation exercise and formulate the recommendation for the government on the way forward. I'm pleased to say that, as I mentioned earlier, so far we've received a number of feedback and submissions and responses. They are all in favor of actually applying the convention to the Hong Kong SAR. So the matter is really about fine-tuning it, and we look forward to listening to the insights and views of the speakers today and in future, and we will welcome any questions and comments regarding proposals or this presentation during the Q&A session. Thank you very much.